Taking into consideration that Ripple is purportedly playing a game of chess in 4 dimensions with its recent decision to pursue an initial public offering outside of the United States, the most recent legal update about the SEC Ripple dilemma is both intriguing and plausible. There are a considerable number of individuals who are of the opinion that this action is effectively laying the groundwork for the Securities and Exchange Commission to file an appeal. Ripple and the Securities and Exchange Commission (SEC) had reached a compromise to suspend the application of a penalty of $125 million, according to a headline that emerged on September 4th. This was in light of the circumstances surrounding the dispute between the SEC and Ripple. Moreover, this may be an indication that an appeal may be filed in the future. A motion to postpone the monetary component of a judgment that was handed down on August 7th has been made by the legal team representing Ripple Labs. Additionally, an order has been issued ordering the company to pay a sum of $125 million. Ripple Labs' legal team is now defending the company in an issue that was brought up by the United States Securities and Exchange Commission (SEC). The legal team was the one that put forward the motion. Ripple's request to delay the payment of the judgment until after September 6th has been allowed, according to a lawyer for the company who stated that the proposal has been approved by the Commission on Securities and Exchange Commission. Ripple's request was granted. Ripple shall deposit 100% of the judgment money, which is around $139 million, into a bank account until 30 days after the deadline for appealing the verdict has passed, as stated in a recommendation that was made by the legal team. Up until the point where the deadline had gone, this recommendation was followed. In response to the ruling, Ripple's chief executive officer, Brad Garlinghouse, referred to it as a victory for the company. Meanwhile, the chief legal officer, Stuart Al-Jarati, stated that the company will honor the $125 million sentence that was handed down. Ripple is the one who made each of these respective claims. To add insult to injury, the chief executive officer was the one who made both of these assertions. Ripple believes that this is a satisfactory conclusion, despite the fact that the Securities and Exchange Commission has characterized the settlement as yet another victory. This was due to the fact that Ripple had. Additionally, there is not the slightest potential that Ripple will be discouraged in any way, shape, or application during this time. Ripple is in a better position to benefit from the conclusion than the Securities and Exchange Commission was of the opinion that the likelihood of filing an appeal had increased more frequently throughout the course of that time period. This was due to the fact that the Securities and Exchange Commission was prepared to comply with this request. This was the reason that the situation arose. According to him, the fact that there have been several lawsuits launched after this one that have listed other currencies as securities has made the situation less unpleasant and ought to be taken into consideration. This is something that should be taken into consideration. Additionally, he stated that this is something that ought to be acknowledged and taken into account. Specifically, he brought up the fact that this new development is something that needs to be taken into consideration. There is no reason to believe that the lawsuit that was filed by the Securities and Exchange Commission is the reason why Ripple and XRP are unable to make it at this moment. This is due to the fact that the case is relevant to the scenario in question. It has been concluded on the basis of the most recent news that was disclosed on September 5th that the initial public offering in the United States, which was crypto media, would not take place despite the fact that it was formally scheduled to take place the previous year. As time went on, the words made by Brad Garlinghouse became more current, and eventually they began to spread throughout the neighborhood. Despite the fact that it was technically the previous year, this is what took place. Have you confirmed that it is still the case right now, even though it is now happening? In spite of the fact that we were already aware of that particular truth, you emphasize that it is still the case nonetheless. The most recent headline that conveys the information that Judge Torres has given his approval to the ruling is as follows. This is the most recent news that includes this information. Owing to the fact that the court made the decision to delay the imposition of the $125 million fine that was going to be handed down in the SEC Ripple case, there is now the opportunity to submit an appeal, which was previously unavailable. This is a consequence of the decision that the judge made. It is believed that Ripple will be able to effectively carry out an initial public offering in a country that is not under the jurisdiction of the United States of America. It could take anywhere from a few months to several years to finish an initial public offering IPO of this kind. In a legal struggle that has been going on for a considerable amount of time, the United States Securities and Exchange Commission has been holding Ripple accountable for its actions, due to the fact that the execution of the civil penalty that was levied against Ripple, which was an amount of $125 million, was delayed. In the ongoing legal dispute that the payment company has been involved in, the door has been opened for the potential of an appeal being filed. Due to the fact that the execution of the sentence was delayed, this is the result. Immediately following the submission of a plea to the court for a stay of proceedings, District Judge Annalise Atoris issued an order to halt the proceedings concerning the monetary aspect of the case's final conclusion. Following Ripple's submission of the request, this order was made available. A deposit of $101.1 million and the penalty, which is equivalent to $38.75 million, will be placed by the corporation into an account that will earn interest and will be named after the attorneys who work for the firm. This action will be taken in order to accomplish the goal of preserving both the acronymical interest and the beneficial ownership of the account. Conversely, the business will not even be able to exert any control over the money that has been allotted to it. This is a significant disadvantage. If a higher court decides to disapprove of the decision that was made by Judge and instead decides in favor of Judge Torres, or if all of the parties agree that the money should be used to pay Ripple's penalty, then the account will be unlocked. Both of these scenarios are possible. Even if Ripple and the Securities and Exchange Commission are in agreement that the ruling is reasonable, the SEC has not yet made a decision regarding whether or not they would initiate an appeal of the order. It has not been possible for anyone to disturb the peace and quiet. In the event that neither Ripple nor the SEC files an appeal before the deadline in October, or if the Court of Appeals publishes a verdict, Torres' stay will continue to be in place for a period of 30 days after the initial deadline has passed. The stay will continue to be in force regardless of which of these are the circumstances. According to the current consensus, Ripple is the owner of all of the information that it requires in order to obtain authorization from the Financial Conduct Authority in the United Kingdom. Ripple is now in possession of all of the information, which enables them to make this determination. This is the reason why this particular outcome occurred. There is a possibility that the approval of Ripple's cryptocurrency license in the United Kingdom could be delayed. This is among the possibilities. This is due to the fact that the Securities and Exchange Commission is not up to date on the possible sum that Ripple may be obliged to pay. It is expected that Ripple will begin the countdown as soon as it has gotten the information, and it will continue until December 2024, which is the day that it will officially obtain its license. The chance remains that by the time December 2025 arrives, an initial public offering in London would be just a few months away. This would be a significant achievement. There is a possibility that this will take place. It is possible that Ripple would not want to go to the trouble of knocking on the door and applying the $125 million penalty to a penalty just to find out that they have already paid it and are now being bombarded with the appeal. Ripple may also decide that it does not wish to apply the punishment to a penalty, which is another alternative. There exists a possibility that this will take place. In spite of the fact that this is nothing more than speculation, the possibility that Ripple would opt to carry out such a task under any conditions is not completely out of the question. The fact that Brad Garlinghouse has made it very clear that he will not be conducting an initial public offering in the United States is one of the many possible explanations for this. There are also a number of other possible contributing factors. Furthermore, there have been statements that have suggested that it may still be carried out in countries other than the United States of America. In the past few years, Ripple has been holding discussions over the prospect of relocating its headquarters to a different site, as a result of which this particular development occurred. Should they come to the conclusion that they needed to relocate, London was one of the cities that they were contemplating going to as a potential new location.